So, David, we're going to try something different today.
Oh, I like that.
We're going to talk about commercial herring fishermen and fisher women.
Oh, is this a red herring or a real herring?
It is not a red herring, it is a real herring. And we're joined by Andrew Shore. And Andrew is a longtime advisor to the American Society of Nephrology. He's also an attorney, which will be relevant for this discussion. So we're talking about herrings and attorneys in law. And he had worked a long time on Capitol Hill as an advisor to the Republican leadership. So he brings a really interesting perspective to this issue.
Well,
Andrew, welcome.
Thank you. Thanks, guys. I've enjoyed my time with ASN. So, as you know, the work has always been a passion project for me. And over the last few years, I've been following the federal circuit courts and the Supreme Court with interest for several clients. So, look forward to the conversation. I'll try and make it interesting.
Yeah,
Oh,
well, we appreciate that, and I guess just to frame the issue for us, can you kind of help me understand why the Supreme Court is looking at a case involving, or I guess it's two cases involving commercial fishermen and fisherwomen, and how that would relate to nephrology? And so, I guess what's the issue, and then we'll get into the nephrology implications.
sure. So the issue has to do with what is the scope of authority granted by federal courts to federal agencies to decide ambiguous statutes through regulation. Okay. So federal agencies can be granted explicit authority by Congress. Congress writes a law and says, Agency X, Department of Health and Human Services, you have the authority to go forth and do something. And that's unquestioned, right? Or Congress writes a law, and one that's often cited in the case, which I think is interesting and relatively easy to understand, not in the healthcare context, but easy to understand, is in 1996, they wrote the Telecommunications Act. And it got cited a lot in the oral arguments because this was before so many things happened with the internet, right? Write a law in 96, and then boom, in the 2000s, you've got an explosion in the internet. And all of these issues that were never contemplated by the Telecommunications Act suddenly required new interpretations. You had all this language that just didn't, and for some people, didn't apply to what was being developed in the 2000s. And so that came up, right? Justice Kagan, Justice Sotomayor kept saying, but wait, these terms made no sense when you wanted to apply it to how the world was operating in 2010 and 11. Now, the petitioners counsel said, well, wait a second, that raises the very problem that Chevron created.
Wait,
Because,
just to
yeah,
stop, when you use the term Chevron, so why did
right.
you refer to
Sorry.
this as
Yeah.
Chevron?
So Chevron was a judicial doctrine that was created to address this issue of agencies that were interpreting these ambiguous statutes where Congress didn't give explicit authority, and the courts, and it was actually Justice Scalia's conservative court in 1984 that said, look, we're not experts on everything, and it really was addressing technical matters, weights, measures, scientific issues, and the court said, look, we're not these technical experts on this stuff. And the government was a lot smaller back then, and there was a lot of conservatives believed at the time that there wasn't again, this is a conservative point of view. There was not this sort of political philosophy among the bureaucracy, right? And so the the court wrote this doctrine, the Chevron doctrine, and they said there was a 2, and now it's really a 3-part test, that the agency where there was ambiguity in a statute, if the agency, one, had the authority, so, if Congress said, this is a healthcare statute, HHS, you could step in. 2, you could come up with a reasonable or rational interpretation of what the statute should mean. And then later on, it was added in most situations that you had to follow the Administrative Procedures Act and put that regulation out for notice and comment to the public. But it wasn't absolute, right? Like this was granted by the court. So now someone could go to court and challenge it, and then the court would decide if you used a reasonable or rational interpretation.
So why don't I stop you there, Andrew? And as I'm listening to you, I'm struck that most of the work that David does kind of falls into this category, where there is an existing law, and over time, the agency, often the Department of Health and Human Services, or an element of the Department of Health and Human Services, like the Centers for Medicaid and Medicare Services, or I guess in the nephrology arena, the Department of Veterans Affairs, those are probably the 2 biggest departments at play here, will propose rules, kind of your sort of third piece about public comment. And we as an organization and other members of the kidney community will respond to those rules. And I could see over time, there's almost this sort of diluting, and I don't mean that in any sort of judgmental sense, but there's the initial intent, and then over in time, every time there are the proposed rules and then the final rules, and we go back and forth, the agency has, if you will, more and more input into what's actually happening with the statute, how the statute's being applied, if you will. So David, my question to you is, how are you thinking about this? I mean, this is an interesting situation in terms of your professional interest, but also just, the potential implications here beyond sort of commercial fishermen and fisherwomen, kind of dramatic.
Well, I'm going to answer your question, but I'm going to add a question back to Andrew with it, because I think this goes to the heart of the matter. So, there's a lot that happens in the kidney space that is regulated by the CMS, the Centers for Medicare and Medicaid Services, but underlying that is statute from Capitol Hill, from what Congress has passed, and in some cases, there's a lot of leeway. There are things that Congress never addressed exactly, specifically, but they've now become part and parcel of how CMS sees its job to regulate things. So before I get into a particular example on that, I was going to add, because I have a couple of them in mind, but I was going to ask Andrew, the conversations that we've been having around this is, for the most part, and this is as a layperson, so as a layperson, I'm posing a question to you as the attorney, is that, it seems as though it's highly likely that the court may turn back the Chevron doctrine. And the catch is, and I was having a conversation just before we take this with someone else about this, and the question is, do you turn back if that's the case, do you think the court will be so broad as to turn it back to 0? Or do they turn it back to 1984? Or do they kind of do something kind of in the middle there, which I think is what the Solicitor General, and I may get this in pronunciation incorrect, but Solicitor General Prelogar had argued that it did not have to go all the way back to 0 or all the way back to 1984. Can you give us a feeling of what you think may happen there?
Yeah, so I thought that question might be coming. So the Solicitor General, so my guess is they will not follow the Solicitor General's recommendation. So if you follow the court and you read or listen to oral arguments, in many of these cases, the Solicitor General, when the Solicitor General knows that it's a seminal case and that they're most likely on the losing end, and it happened in Bruin, the Second Amendment case. This happened in some of the precursor cases. Remember, this isn't the first Chevron case or Chevron-like case they heard.
Yeah.
The West Virginia versus EPA, which was a very similar case dealing with what we call the major questions doctrine. You know, can an agency have a broad impact on the economy? And the court said, no, there's no statutory authority for this. You can't just wave a wand and change the economy because you think you have the authority. You know, the Solicitor General will come in and try and say, okay, well, here's an option for you that I suggest you follow. And so I don't think the court isn't going to substitute one fiction for another. Right. The court, so we have to, so let me answer that question with a little bit more background, right? So the court, this is a court that is a textualist court. And if you look at the cases and you look at the decisions that are in this genre, they follow the plain meaning of the Constitution or the plain meaning of the statutes that they review. In 22, they heard a case, the American Hospital Association versus Becerra. It was actually a unanimous decision. It was a 340B case, you know, hospital pharmaceutical payment case. Unanimous decision where the court said, look, the Department of Health and Human Service did not have the authority under the statute to take the action it did. There were no words in the statute that allowed the agency to do the very thing that they set out to do. So this court, and again, this is not a value-based judgment on my part. This is just, you know, Roberts has always said, we're here to call balls and strikes. And so if you look at how they rule, right, they're textualists. They read the words on the paper. So I suspect that, you know, what they're going to do is they're going to look for a way to, you know, say that the agencies are required to, you know, follow the plain meaning of whatever is in the statute. Now, in terms of what is currently being followed part and parcel in practice in the agencies, that came up multiple times a couple of other ways. They could engage in what's called stare decisis, right? Like that, which means that the rulings that the courts have already made would stay on the books, and you would follow the current law.
Now, did the Solicitor General suggested that in her remarks?
I think Kagan and Sotomayor.
Okay, sorry.
Yeah. And petitioner's counsel in the first case, I don't want to put words in his mouth. I'm not sure he completely ruled that out. And I can't recall if any of the conservative justices completely ruled that out. You know, there are two ways to do that. They could put that in opinion, or they could just let these cases be relitigated, case by case. Remember, for the practices that the agencies are currently engaging in, someone would have to challenge those practices for them to be overturned. So it's not like you would wake up the next day and suddenly all the things that HHS or CMS are doing would automatically become unconstitutional. Someone would have to challenge them.
So I guess, David, I don't know if this is a question for you or for Andrew, but I'm going to pose a hypothetical, and I don't want to derail us, but you know, there's increasing consternation in the kidney community, including within ASN, about the bundled payment within the Medicare ESRD program. If the courts rule in Chevron the way Andrew is describing, could a member of the kidney community sue to have the bundle essentially overturned? Or is, I guess, or is there enough in statute that that would be impossible? I guess that's the question.
Yeah, I mean, so I would have to read the statute, but the question is, does the agency have explicit authority to create the bundle or implied authority? If they have explicit authority to create the bundle, then there's no means by which to challenge the statute. The other thing is, remember, it's very expensive to go to court and challenge the statute. Also, if there are organizations out there that like the bundle, then you're going to have a lot of, right? It's not as simple as just waking up one morning and filing a suit in federal court. Right? It's a very complicated, arduous, and expensive process. So, just because the doctrine might get overturned, and by the way, even if it gets overturned, it has to be replaced with something, right? You still need a standard by which the agency's behavior is governed, because it's the court. Remember, the agencies don't get to be arbiters of their own behavior. It's the courts that determine whether or not the agencies are following the law. And I think over time, a lot of people have forgotten that, because we've become so accustomed to the agencies writing and enforcing these regulations. We just assume that the agencies are the policemen of their own behavior. And and so as you kind of alluded to, David, oh, well, the agencies just do this and become practice. But it's really the courts that are in charge of the agency's behavior. So this court is going to have to come up with a standard.
Sure. I'm gonna jump in here just with this, and so for our listeners, to help our listeners a little bit in the name time, because we don't want them to be overly concerned. I hear you.
Yeah, I don't think they should.
Yeah, my guess is also, and again, I'm stating as a layperson, not as an attorney, is that particularly in the case of the ESRD benefit and the end-stage renal disease benefit within Medicare, and a lot of the work that goes on there, Medicare, I think there's a lot of underlying law there that kind of directs that. My suspicion is that probably in healthcare, the bigger areas will be the one, such as the one that you've already mentioned, would be the 340B case. It would be cases like that that are not really just nephrology specific, but of healthcare in general. So what I'm hearing from you is, and what you just said is, our listeners shouldn't be like panicked that this is going to be
right.
Basically,
right. I mean, where there's consensus on policy, I just don't suspect anybody's going to wake up and want to challenge that policy. Plus, even if there's a minority of disagreement on something in our space, and there's an overwhelming majority that supports what's going on, they're going to have to fight the majority, right? And we're going to bring pressure and resources to bear to support our position. I think a lot of this, just to give maybe a non-healthcare example to the audience that might provide some clarity, like a more layman's non-healthcare example to all of this. So a lot of the concern in some conservatives' quarters on Chevron has to do with criminal law. And, a lot of the issues that arise is that you have the administration of the executive branch that both enforces criminal law and writes criminal statute through regulation.
Just as I'm thinking about what you said there, but also earlier. So, last year, I know Lauren, I want to go to Lauren too, because I know she gets to have the last question as our producer. But before we go to Lauren, I guess a question I would have for you is, last year, Congress passed pretty transformative legislation to change the entire transplant system. It sounds like that's the kind of situation where how the agency begins to implement that statute is where this could really take effect, because I would think they would be much more limited or prescriptive in terms of much more circumspect in terms of how they handle things.
Yes. So that bill, I mean, as I recall, the Congress granted them a lot of authority, so I think most of
Right.
it's explicit. Where it could be problematic is, ASN is in the process of working a lot of bills on Capitol Hill, dealing with transplantation and incentives for transplantation in granting authority to a number of agencies. And I think now we should be revisiting those bills to make sure that they're drafted in such a way that the authority is explicit. We want to make sure our legislation is really tight and that the authority, that it does what it says it does. But more importantly, I think we need to future proof the legislation we draft, and that's going to be really hard, right? That we don't want to end up with the Telecommunications Act problem. And how we do that is going to be a real challenge. And that's where we're all going to have to put our heads together and sit down and say, how do we plan for the future? How do we know what the future is going to look like? How do we know what organ donation, transplantation, how do we know what the income levels of people are going to be like, and how these agencies are going to deal with that and dial up who donors are, what their socioeconomics are, and how they're going to pick and choose who can donate, who can't donate, and what the health factors are going to be, right? Like simple questions about who they're going to be able to pick and choose from in terms of what a donor looks like. Think about the questions that the Department of Defense has wrestled with in the past about what a healthy donor is, and who can serve in the military, right? Because now that the class of people who can serve is very different because, people are healthier. And so the ability to qualify to serve in the military, if you've donated a kidney, looks much different now than it did 10, 15, 20 years ago.
Yeah. So Andrew, I'm going to turn it to Lauren. So our tradition is she gets to, no, this is great. So she gets to ask the last question as our producer. So Lauren, I know this is a topic you're really interested in.
Yeah, so thanks again for joining us today, Andrew. I guess a good way to wrap up this conversation is, when can we expect the court to release a ruling on this?
So October, this is called this term, we're past the October term, we're in February. So it's probably going to be, I expect probably in June is when it could be earlier, but probably not. I suspect maybe in June that they'll start releasing these opinions, is what we typically look for. Justice Roberts will assign someone to draft the opinion. Kavanaugh had a lot to say. Kavanaugh wrote, as I recall, the American Hospital Association versus Becerra opinion. And so it wouldn't surprise me if Kavanaugh wrote this opinion. This is pure wild speculation with no foundation except what I've seen. And then so the way it works is he drafts it and it gets passed around for comment. But yeah, it's going to be a little while.
Yeah. So it looks like June. So, well, Andrew, thanks for joining us. And David, always good to chat with you. And Lauren, thanks for all your help. And this is a really interesting issue. And I have a feeling we'll be continuing to discuss it after June, if I had to make a prediction, because I think it's going to be quite influential.
And as you referred earlier this week, and I'll find out whether I still have a job, whether rulemaking still exists. But Andrew,
yeah, I think
you'll have a job, David. They will still be making they will still be making lots of rules. I think they might even be making more rules.
Yeah. Well, it's interesting too, because I hadn't thought of that implication, but I think you're right. And I know David's being his tongue is firmly in his cheek. I think the other thing here is it changes kind of how the Congressional Ledge Council process works and how people think about proposing legislation and things. But that'll be a discussion for another day. So Andrew, thank you very much. David, Lauren.
This podcast is copyrighted by the American Society of Nephrology. All rights reserved. All content in this podcast is for informational purposes only and is not intended to be medical advice. This podcast should not be used in a medical emergency or for the diagnosis or treatment of any medical condition. Please consult your doctor or other qualified healthcare professional if you have any questions about any medical condition or before taking any drug, changing your diet, or commencing or discontinuing any course of treatment. Thank you for listening to this podcast from the American Society of Nephrology.